longtime advocate on behalf of individuals who have found themselves under the system of the public curator. And we're going to hear today how we should avoid that happening and being declared incapacitated, and what steps can we take in advance so that we are protected. So without further ado, Ura's complete bio is in your program. Ura, thank you for doing this. I'll turn it over to you.
The title I was given is Understanding the Role of the Public Curator, Your Last Resort. First of all, I just clarify that last bit of the title. The public curator is never a last resort. It's now a resort at all, neither for young people nor for old people, from our knowledge, experience, and the archives we have. Getting into the topic, on November the 1st, 2022, 3 years ago, not even 3 years ago, a major overhaul in the legal protection of incapable adults came into effect. Among the radical changes, completely overhauled, the regimes of protection of curatorship and judicial advisors have been abolished, and only tutorship remains. I imagine that is why I was invited to speak on this event today, because of all the new procedures and regimes that have been introduced by this change, that came into effect. The first question that I was given is on the program, if you look at it, is how to avoid being declared incapacitated. I suppose that means how to avoid being declared legally incompetent, not incapacitated, unless the person is cured of the underlying cause leading to legal guardianship. There is no avoiding it, because incompetency or incapacity stems from uncontrollable congenital or accidental factors. Legal incompetency is designed as a measure of protection for the afflicted person and his property. Legally, it is defined as a condition of incapable of caring for himself or herself, or of administering property. That's what the legal definition in the Civil Code of incapacity, legal capacity, or incompetence, by reason, in particular, examples of illness, deficiency, or debility due to age, which impairs the person's mental faculties or physical ability to express his or her will. That's the legal definition from the Civil Code, just to start off and put us within the framework. However, with the proper planning and advice, a person may mitigate certain undesirable or adverse effects, or choose better options. That's to clarify the first question. Second, what is the steps taken in advance to protect ourselves? Here we must ask, protect yourself from what? The reply is protect against neglect or abuse when you're become incapacitated, partially or fully. Then we may ask, by whom? If you become vulnerable, you become dependent on other people and institutions who will take care of the decisions on your behalf. First, if incapable from yourself making inappropriate or questionable decisions, you have to be protected against that immediately beforehand. Second, you have to be protected from substitute decision making or the tutor, or from making poor decisions or what one's clearly not in the best interest. Third, you have to be protected from the public curator. It is a highly intrusive state body whose mission it claims is to protect protection of incapable people, yet it has not been one that has been without reproach. If you come to our office or you want information, we have, I think, over 25 independent studies since 1997 criticizing the functioning and the failings of the public curator in that role. it itself has not been a model of good administration. In the field of incapacity, the public curator intrudes in three ways. The public curator is obligatorily part of every court proceeding involving an incapable person, adult, senior in our case. So immediately, it is involved and plays a crucial role, indispensable role. The public curator can also be appointed by the court as tutor when no one else is available or willing to accept the responsibility, and will then take the administration of an incapable person and their property, which means government bureaucrats who do not know you and have no relationship to you assume that role. If it is discontent with the performance of either a private tutor or a temporary representative or an assistant to a vulnerable person, the public curator can have that person removed and even have itself appointed to replace your private tutor or private representative. So in all aspects, it can intervene, and may intervene into your life. So returning to the initial question, what steps can be taken in advance to protect yourselves while, if you become incapacitated? While capable, you can execute a mandate in anticipation of incapacity, which now has a new title. It's called a protective mandate, which is a legal instrument that is done by the person, by yourselves, or anyone you know that requires that service, or a representative. The document, the instrument, enables you to appoint someone trustworthy in whom you have confidence to make decisions on your behalf. Your wife, your children, close friends, whoever you trust. It also allows you to describe the powers and duties and their limits and any special instructions and oversight to attribute to the mandatory. The person who's designated is called a private mandatory, rather in opposition to the public curator. By October 2024, still less than 50% of Quebecers had prepared a protective mandate. Since we now live significantly older than our ancestors, our predecessors, it is advisable to add it and to keep it with your important documents like your passport, your will, your insurance policy, etc., as a protection. You can have it done, prepare the private mandate by yourself, getting a copy from the public curator's office to supply to you. You can get it online also. You can just fill it out in your house, at home, or wherever, or with assistance. Or you can consult a lawyer, consult a notary, or any professional experienced, knowledgeable in the field, preparation of these things. And that way you appoint, like I said at the beginning of the section, the person who you choose, who you want to look after you and your property, and not fall by chance under the hands of state bureaucrats. The next question I was assigned is the temporary representative. These are among the changes now, the new changes. Temporary representative is one of the new features introduced on November the 1st, 2022. The question is, what is the difference between tutor and temporary representative? Tutorship, if you're incapacitated, which is the only regime of protection that now exists with the curatorship and the judicial advisor having been abolished, is a permanent representative or substitute decision maker appointed by the courts for all decisions and acts, and can only be changed by the court. So you're stuck. Once you have a tutor, you have to go to court to homologate the act, the instrument that you prepared while you were well, or you were still capable, and it can't be changed unless you return to the court by a judicial decision. On the other hand, a demand to appoint a temporary representative is presented to the court on behalf of a legally incapable adult for a specific risky or important act for a brief period and terminates when the act is accomplished rather than lasting permanently and comprehensively. The temporary representative is a limited act, a limited instrument, and once the act is completed, is realized, then it ends. And the person, the afflicted person, is not deprived all his rights continuously until they pass away. The court examines the request and fixes the modalities and conditions of exercise conferred to the temporary representative. Beyond the specified act, the adult is not deprived of his legal capacity. So just for a limited purpose, for a short, brief time, and not a continual and comprehensive act like a creation of a tutorship, which deprives the person of, for the rest of their life, of their capacity, legal capacities. It can be accompanied, starting by the standard guardrails and safeguards, such as drafting an inventory of the assets of the person, so nothing disappears or is mismanaged, and providing the accounting of the management of the temporary representative. So there are protections built in this instrument that come from the law itself. The assistance measures is another instrument. However, instead of going to court, you address or go to a public curator and present a person that may help you if you are not fully incompetent at all, legally incompetent, but still have a difficulty and require assistance in either looking after yourself or your managing your property because they're beyond your ability or your means because of limitation, but you are again not fully incompetent. Again, it's like the temporary representative, but you present it to a public curator, and the public curator will help you. Will first verify upon the ability and the interest of the person you designate, in order that they assure themselves that will not be abused or taken advantage of or exploited. And if they check the bona fides, they will also consult the family members or people, significant people that care for you, or look after you, or help you. And if they all agree, they can oppose, they can dispute, and then the public curator will make the final decision. So it's not a court proceeding or procedure, but a voluntary procedure by the person who has some difficulties to care for themselves or manage their property, but are not deprived of all their rights as a tutorship would do. So those are the new changes, the new features that have been introduced since November 1st, 2022. It's designed for a person who is not cognitively incapable, which requires the appointment of a tutor or homologation of a protective mandate, but who, because of some difficulty, is nevertheless vulnerable. So it's a vulnerable person, but not incapable person. A distinction of degree. It is the question of degree of impairment, disability, or dysfunction. The assistance measure foresees presentation by the adult or a lawyer or notary on his behalf to the public curator the designation of someone chosen by the vulnerable person, not as a substitute decision maker such as a tutor, but to assist decision making on important or complicated matters beyond the ability of the vulnerable person. Two family members or intimates are notified by the public curator. Again, it's processed by the public curator, and each can oppose the request. So you have some protection right there at the start against exploitation, or abuse. However, the vulnerable person is not deprived of his legal capacity, as I stated earlier, and takes the ultimate decisions. The decision is finally made by the person themselves. The assistant only advises the vulnerable person and oversees the act that the person does, but does not take the decision themselves. So there's a difference between the curator tutorship now and the assistants. Thank you.
If you have a question for Ura.
I didn't hear the word doctor's report.
Yeah.
Oh, that's as far as the procedure itself goes. First of all, as I stated, it's not a tutorship. It's not a regime of protection for the person that is incapacitated. So you don't require to go to court. The psychosocial report by a social worker and the medical report by a doctor is in the event of incapacity. Here, for the assistance measure, you're not incapacitated, so you don't produce the same proof as you do in court. However, you have to have a disability, a difficulty. The law says a difficulty only, which is pretty wide-ranging. The requirement is not necessarily a medical condition. You don't need a doctor's report or even a psychosocial report. It's a difficulty which the public curator will evaluate by themselves upon meeting you or the people from your family that they have to consult also. So there's a distinction there again. It's not a court proceeding. You don't have to do the quality of proof that's required in court. It's a voluntary status by approaching the public curator for help. But it's called an assistance measure. Completely different distinctions.
Are there any other questions?
We have one here, Janet.
Janice?
Yeah. It seems so complicated. If I become incapacitated, then I've got a son who I hope will take care of me. But I can't trust him at that point? Like I have to go through the courts?
Well, you have to go through the courts to prove it that you're. But if you've done it in advance, you have a private appointment of your son in your case.
Yeah.
Then the court will simply obligate your choice. But you still have to go to court, which means you probably have to get a lawyer or a notary. Well, notaries have to represent you in court, but then a lawyer.
So I'm not looking forward to this.
No, but why you have to do that, it's for your protection, a protective measure. It's provided by the law, it comes from the laws. You have no choice.
Okay. All right.
Okay, for the sake of time, we're going to take one more question.
Thank you for your speech, Mr. Ura. One easy question. Is all the services provided by the Curator Public du Québec are free for the people who ask them to help them in the case of incapacity? It's a large question. Explain to us, is it free for the family?
Yeah, that service is free. There's no charge because there's no one under the public curator that the public curator manages. So it's they can't charge for not doing anything. It's only an advice first of all, and vetting both the person you choose under the assisted measure. Again, it's a completely separate document or measure from the tutorship.
Thank you, Ura. Thank you very much.